Okay, good morning everyone, and welcome to our webinar for commercial landlords who are trying to manage the relationship with their tenants during these difficult times. My name is Sarah Glynn and I am the marketing manager for Kuits. For those of you who might not already work with us, we are an award-winning law firm based in Manchester city centre. Obviously, we're not coming to you from the city centre today. We're coming to you from our spare rooms and kitchen tables. So this is our first ever webinar and my first time hosting. So please bear with us if things don't go to plan. Some of the speakers have children. I have a neighbour who's decided now is a great time to mow his lawn. So please do forgive us for any interruptions or noises in the background. Just before we begin, a little bit on what Kuits has been doing to help businesses since the start of the outbreak. I won't go through this in any great detail, but I think it's enough to say that we do have a COVID-19 task force set up to help clients across a whole host of different areas, including employment, obviously property, commercial contracts. So please do get in touch with us on any legal or commercial areas that you might be having issues with. If we can't help you, we will know someone who can. So please do feel free to contact us with that. So here's the agenda for today then. We'll be talking to you for probably around the next 30 minutes. I'm just going to start with some housekeeping and practicalities, although I obviously don't need to tell you where the fire exits are, so that will be quite short, and ways to connect with us following this. I'll then be handing over to my colleague David Moroney, who will be taking us through the landscape for landlords at present and potential remedies that they can possibly use while trying to manage those relationships with tenants. We'll then be handing over to our other colleague, Chris Hardy, who will be looking at managing your relationships with lenders and funders. So obviously, a lot of landlords at the minute probably feel like they're between a rock and a hard place and you're having to manage both sides of the relationship. So we really wanted to make sure that we're covering both angles with this webinar. And then it'll be over to you to ask some questions at the end. Ways you can connect with us then, obviously, by telephone, by email, those are all still working. We're still working from home. You can visit us at www.kuits.com. On there, you'll also find a COVID-19 knowledge centre that we've set up. This contains lots of different insights from all different teams across the business on some of the areas that we've already touched upon. You'll also find links there to other webinars that we might be putting on, such as this. And there's also going to be a form on there where you can join our mailing list. So if your inbox is anything like mine, you've probably been absolutely deluged with different bits of content from various businesses. We try to keep ours quite succinct really and quite concise. We just send one bulletin per week, which goes out at the end of the week. And that has on there all of the different insights that we've published that week to the Knowledge Centre. So please do go and join our mailing list. It also means that you'll be alerted to any new webinars and you'll get these invitations as and when we publish them. And then obviously we are on social as well. So please, follow us on Twitter and LinkedIn. And it's just another way of getting our insights. So just a couple of very quick bits on housekeeping. We would like you to ask questions and please do feel free to do that throughout the webinar. To do that, you can go to your Q&A button, which I think should be at the bottom of your screen. And you can ask a question on there. You can ask it completely anonymously. This webinar is being recorded, so if you would prefer to do that, obviously you have that option. And then we'll come back to the questions at the end and answer those for you. If someone else has asked a question that is also relevant to you, you can upvote that question to the top and you can do that by pressing the little thumbs up symbol next to that question. Following this webinar, we will also be sending up a follow-up email to you that will contain the link to this recording. Please do feel free to share that with colleagues or obviously anyone else that you feel might benefit from that. Share it on social media and things like that. And we'll also put in all the links that I've mentioned to the mailing list and the Knowledge Centre, and also the contact details of the panellists if you would like to contact them afterwards. So please allow me now to introduce you to your speakers. Both are colleagues of mine, partners in the commercial property department. They've both got experience spanning across all aspects of commercial property. Dave in particular is very experienced with acquisitions and disposals of portfolios and also property investment, as well as obviously the topic that we're covering here today. Chris is particularly experienced in acting for lenders and borrowers in respect of loans on property and refinancing portfolios. And as I say, he'll be covering working with lenders at the end of this. So without further ado, I will hand over to Dave, and he'll be taking you through the landscape for landlords.
So I think you've disabled my video, which is probably the wise thing to do.
I have asked you to start it. There we go.
Thank you. Good morning, everyone. Firstly, I'd just like to tell you a little bit about Kuits before we get underway. As most of you will know, we're a well-established city centre law firm, just celebrated our 111th, I think it was, birthday. Our property department is one of the largest departments in the firm, spanning approximately 50 fee earners, specialising in investment and sale work, which is my particular field on a day-to-day basis, development, landlord and tenant, banking, property finance and residential property. During the current crisis, what we found ourselves doing, and my ordinary day-to-day work has changed significantly. We are now advising landlords on a far more regular basis due to the changing landscape. In terms of tenants, which I'm sure you're all encountering, who are in difficulties when it comes to paying rent going forward. And we have been working quite closely with those landlords to try and resolve their issues. Obviously, the landscape has changed significantly during the start of 2020. Which has culminated us all sitting here today, rather than being at our desks in the office, and also in the Coronavirus Act 2020, which, to paraphrase the relevant section, has placed a moratorium whereby a right of entry for non-payment of rent may no longer be enforced. This moratorium is applicable until June, with an ability to extend. I think there is a strong feeling and expectation that it will be extended beyond that. It should be stressed that it's simply a moratorium against landlords taking action for re-entry of properties for non-payment of rent. It is not a moratorium for tenants not want tenants paying rent, so tenants are still obliged to pay rent. It's just that the landlord has lost one of its greatest levers in enforcing that obligation. Unfortunately, whilst protection was afforded to the tenants in that regard, there was no corresponding protection for landlords in relation to bank enforcement. As most of you will appreciate, more often than not, rent which is paid by a tenant is utilised to make either interest or capital payments pursuant to loan documentation, and also a failure to collect that rent can trigger a breach of landlord covenants and funding documents. So there is an argument that the Coronavirus Act was slightly one-sided and possibly favoured a tenant rather than a landlord. There is also potential impending legislation in terms of insolvency, which will have an impact upon what we discuss later in this webinar. It is likely that there'll be a suspension of wrongful trading from 21st of April, which will take effect retrospectively from the 1st of March. And there is also a 90-day moratorium to assist with liquidity issues, which has been mooted. I don't think there is any real definitive view as to what that will contain yet, but it seems to be with an aim to allow companies to continue trading, thereby preventing enforcement of contractual termination clauses, an example of which might be a landlord break. Essentially, it feels analogous to the relief from forfeiture or moratorium against forfeiture. There is, though, a concern which has been discussed that this could actually constitute and develop into a moratorium against winding up actions against companies who are struggling with solvency issues, which, like I say, will have an impact on what we discuss going forward. There are a number, I'm sure you've all read them, of further articles and commentary out there. None of these are, there is a suggestion at the moment, were passed into legislation, but there are a large number of tenants, particularly in the leisure and retail sectors, now calling for a moratorium against all credit enforcement action, which arguably would be equally beneficial to landlords in that it would insulate them from bank action, but would essentially render a landlord completely toothless in the event that a tenant was unable or declined to pay their rent. So what we're finding is tenants are generally now obviously struggling because of the climate. Clearly, most people are working from home. Most premises are no longer available for use. So tenants are struggling with cash flow and liquidity issues, and tend to be approaching this in one of two ways. The first is to seek to obtain some form of concession with the landlord. The second is to tell a landlord simply that they won't be paying rent. What we're finding is the latter, slightly more aggressive confrontational option tends to be taken by large national tenants, whereas local retailers tend to be taking a more conciliatory approach. As we'll go on to discuss shortly, I'm finding, I think it is natural that the manner in which landlords are responding to these requests or demands is very much dictated by the nature of the request or demand. I've also encountered tenants already seeking to explore a number of potential legal options in relation to their inability to utilise premises. The first is that some tenants are seeking to explore a derogation from grant argument, whereby they are no longer able to enjoy what they had contracted to enjoy. The landlord has withdrawn or prohibited them from doing so, is essentially the gist of the argument. I don't believe that is a viable argument, because lockdown is not optional by landlords, it is enforced by government. It could become a relevant argument if a landlord chose to close his premises rather than keeping those premises open despite the ability to do so. Frustration is another slight flavour of the month at the moment, whereby a supervening event renders a contract incapable of performance. This has been discussed in some commentary. Nobody has actually tried to run these arguments or gone to court or anything of that nature yet, as you might imagine. Again, I would view this as unlikely to be successful. The interruption, as painful as it may be, is perceived by most people to be temporary. It is not something which completely prohibits that contract being capable of performance. The expectation is that within a period of time, we will all be able to re-enter premises that are leased and continue trade on a day-to-day basis. So I don't believe that frustration would be a successful argument. Force majeure has been bandied around, which is a few tenants have been seeking to explore that. The issue they have with force majeure is that you have to have an express clause in a contract to seek to utilise force majeure. It is not something that can be implied into a document, and very few leases, if any, would have a clause of that nature in it. It would be analogous to almost a rolling break from an investment perspective. Tenants are also looking at the possibility of utilising loss of rent clauses in leases. Again, we do not believe these will be likely. One, because a risk of this nature is very unlikely to be an insured risk. And secondly, most loss of rent clauses are predicated upon the premises not being capable for use due to damage or destruction. As such, despite the moratorium, tenants tend to have actually very few contractual options open to them. They are very much falling back on the initial two approaches, which is to seek to engage with their landlord, or to simply take a more robust and aggressive approach and decline to pay rent on the basis that they know they're insulated from forfeiture. As I mentioned, moving on to landlords' responses. Really, the landscape for landlords is difficult, because the government's aim, we believe, is to enable tenants to survive. and they believe that the moratorium against forfeiture and other steps that might be taken are driven largely by that. And as you'll have seen, no doubt, in the media, landlords who are taking an overly aggressive approach are receiving adverse publicity. There's been a number of articles being extremely critical of landlords who have taken an aggressive approach and have not tried to accommodate tenants' responses. So that is something that a landlord has to be mindful of. So there is an element of trying to achieve a balance and trying to come to a satisfactory conclusion which benefits both the landlord and the tenant, rather than necessarily taking a big stick to the issue. However, as I mentioned, I find landlords' approaches are dictated by a number of factors, one of which we have just discussed is the way the tenant approaches the issue themselves. So what options does a landlord have? Well, landlord's responses, I say, are driven by a number of factors. The nature of the tenant request, overly aggressive requests tend to receive a response in kind. The nature of the premises might be a factor which a landlord considers. There may well be less sympathy from a landlord's perspective with office tenants who are capable of working from home and would view an interruption as a more temporary nature than, for example, leisure tenants who have a complete inability to use their premises and operate their business. The nature of the tenant may also be relevant, and that is a factor that I'm finding a lot of landlords actually do have due regard to. Small local retailers or local operators tend to be viewed far more sympathetically than large national tenants who, there is a perception, rightly or wrongly, might well be seeking to take advantage of this situation by immediately refusing to pay rent for the March quarter day, which, when all said and done, is only 2 or so weeks after lockdown commenced. And the nature of the landlord themselves, of course, an overly aggressive approach is likely to, or could potentially, create bad publicity and have potential damage on a landlord's reputation and ability to let the premises in the future. I say most clients that I'm acting for, I find, are striking a balance in the way they're approaching this. They might be, it isn't a simple one solution for all. They might well be taking a far more aggressive approach with a national retailer who they perceive as being exploiting the situation, as they would with, let's say, a local gym operator who they realise can't operate their business, would be likely to face serious solvency issues if they were pursued and they're trying to reach a compromise with. So as I mentioned there, it's really just on a case-by-case basis, and then this is the exact point we've just discussed. Independent gym, likely to be, I'm finding landlords are likely to be quite generous, quite relaxed, and well, relaxed is probably the wrong word, but quite pragmatic in their approach. National retailers, our clients are tending to be far more robust in the way they're dealing with them. There are landlords, and there is an argument that a landlord, before turning their mind to what rent concessions might be given, that they would want information from their tenants, cash flow, for example, to ascertain exactly the impact on their business. But there is a thought that might be over egging the pudding slightly. Most people can make a sensible decision at this stage as to whether a tenant is likely to suffer severe financial hardship as a consequence of the ongoing crisis, and whether their requests are reasonable. So landlords seeking a conciliatory approach have been likely to offer the following: moving payment cycles, mostly from quarterly to monthly, which affords tenants a degree of flexibility in relation to cash flow, but also maintains an income stream for the landlord. Allowing a rent deferral rather than rent-free. The rent remains due. It isn't simply written off and is paid by reference to a future event. Now, for example, that might be a date, or alternatively, it might be the tenant's premises reopening for trade. There will then be an agreement as to the period of time over which that is to be repaid. It might depend upon, or could well depend upon, how long they've been closed for and how much rent is accrued. For example, for every month of rent that you've accrued, you might allow the tenant 2 to 3 months to pay it back, to enable them to get back on their feet and become trading again. Because the reality is, once premises reopen, there might well be a lull in footfall until things are back to hopefully normal. The other option, of course, is to try and make this work for both parties and seek to, want a better expression, trade a rent-free for a favourable landlord concession. That might well be the removal of a break or the extension of term. For example, if you had a tenant who you knew wished to stay in occupation of premises prior to this happening, who had a break in maybe 18 months to 2 years, it might be possible to trade out and have them vary their lease to remove that break in return for a more substantial rent-free, which would give the tenant an immediate cash flow benefit, but equally would add value to the landlord's reversionary interest going forward. Moving on, some landlords are taking a far more aggressive approach, and the options open to a landlord taking a more aggressive approach. There are still a number available. Obviously, there are straight contractual remedies. A tenant not paying rent, they're not just necessarily kicking the can down the road and accruing a bit of interest on rent that hasn't been paid. It is a breach of contract, and a landlord is perfectly entitled to recover their foreseeable losses from that breach. It would accordingly be prudent from a landlord's perspective to put a tenant on notice of the fact that, particularly if the property is charged, that losses which may flow from the tenant's breach could be considerable. CRA is still an option, although it is severely inhibited by social distancing, but it is still possible to seek to apply pressure by the service of the 7-day notice, which would still be viable, we would hope, once, provided we're not locked down for a considerable period of time, would still be viable once the current lockdown has relaxed. The approach a number of landlords are taking now, where they wish to take a more aggressive approach, is to threaten to instigate insolvency proceedings. As I touched on earlier, there is a concern amongst landlords that the government may be about to close the door on this, seeing it as a backdoor mechanism to forfeiture. With an individual, this would be via a statutory demand, which would give them 21 days to pay the rent. You can also use a statutory demand against a company, but that's not necessary, and a simple demand might will be sufficient. The other weakness with insolvency proceedings, of course, that it would necessitate court involvement. Courts currently aren't open for business, and it might well be, if you end up in a court with this, it would not be looked upon favourably, as it would be seen as a way of circumventing the moratorium against forfeiture. The actual service of the notice, though, from a landlord's perspective, may well be seen as leverage. And landlords should also not overlook the fact that they might well have contractual security. They may have an authorised guarantee agreement whereby they can pursue a previous tenant. They may have a guarantor who they could pursue, and they may also have money pursuant to a rent deposit deed which they could draw upon. One interesting point of note around rent deposit deeds, and again, this has not been explored in any great detail, but it is something which a landlord could bear in mind, is that the most well-drafted rent deposit deeds will require a tenant to top up the rent deposit in the event that it is drawn upon by the landlord. They will also include a provision whereby a breach of the rent deposit deed would constitute a breach of lease and would lead to re-entry. So there is a query as to whether, or a question as to whether, if a landlord utilised a rent deposit deed to pay rent and then a tenant was unable to top that rent deposit up, could a landlord forfeit on that basis? Because that would probably not be non-payment of rent, but would rather be breach of contract. Like I say, nobody's explored that. It's just something that we have in mind as a possibility. As with everything, care needs to be taken with the way that tenants are approached. So correspondence with tenants needs to be well drafted, and it is recommended that a solicitor should look over it. A landlord, for example, does not want to inadvertently waive a breach whereby they could prejudice a future action, or inadvertently agree to a variation by way of just simple email exchanges. Care needs to be taken to make sure that documents are drafted correctly. Apologies, I'm just distracted by somebody knocking at the door. We would like to see concessions ideally drafted by a side letter, which we would expect to be personal to the tenant, clearly set out the concession made and the duration of the same and how it can be brought to an end. We would expect that to be the more minor arrangements, for want of a better expression, changes in rights, rent cycles and deferments of rent. If we're looking at more substantial amendments, deletions of breaks, etc., we will be looking more for a deed of variation. As mentioned, they need to be carefully drafted, because what you need to make sure is that you're not agreeing to something you don't expect to agree to. You're not, for example, releasing a guarantor inadvertently. Then, in terms of expected developments, as I think we've already touched on these to a degree, but there is a concern, or from a landlord's perspective, that there may well shortly be a moratorium against winding up petitions, which would, to all intents and purposes, shut down the landlord's other main recourse against tenants. Court closure in any way inhibits that. A possibility of statutory rent holidays, albeit there's been no real definitive commentary around that other than beyond what tenants themselves are requesting. Then what we're finding, and we're really turning our minds to the future now, when hopefully we're all beyond this, is tenants are already starting to think about what happens if they encounter these issues in the future, and the Corona clause or COVID clause, which tenants are seeking to introduce to leases. The broad concept of these is that if a government enforced lockdown occurs again, then the tenant has a number of remedies already built into their lease. So they're building themselves in the contractual remedies that they're missing at present. To date, I've already seen tenants requesting break clauses. As you can imagine, from a landlord's perspective, they should be strongly resisted, because the impact on investment value is huge. A bank will assume, or a lending bank will assume, that that break clause can be exercised almost immediately. The ability for the landlord, or excuse me, the tenant, to benefit from a rent-free, again, that's likely to have a significant effect on the investment value of the lease. A landlord should also consider whether they could actually obtain any form of loss of rent insurance against an event of this nature going forward. It would have to see how the insurance market evolves in that regard. I have already seen landlords offering a form of shared risk, whereby, for example, it is agreed that if something of this nature happens in the future, the rent is split 50-50, the tenant pays 50% now and defers 50% until they're able to reopen. Again, these are largely commercial decisions. There is a feeling, and we've seen a number of heads of terms coming in from national retailers who are approaching this issue quite aggressively, who are not seeking clauses of this nature. So it is an evolving area of law, and a landlord should not assume that they have to give a clause of this nature, or this is the only way they can get a tenant into occupation. If, however, a landlord does feel they're agreeable to a clause, to this form of clause, then again, care needs to be taken as to how it's approached. We would suggest it's by way of side letter. There should be limitations on its scope, ideally by reference to the current pandemic, and it shouldn't be an open-ended lockdown, and possibly also limiting its application to the period in which the premises cannot be used due to government requirements. So, like I say, there's a lot of thought that needs to go into the drafting of these clauses going forward. There is by no means any form of industry standard approach or industry normal approach, and these clauses will, to the extent that they become ordinary, will evolve. But as I mentioned, care needs to be taken even in the concept as to whether you'd enter into a clause of this nature. It is arguable that this is a one-off event. An event of this nature probably hasn't happened for 100 years and might well not happen for another 100 years. So we don't want to be too knee-jerk and reactionary in putting clauses in specific to this. And I think that's all from me. So I hope Sarah will step back in now and hand you over to my partner, Christopher Hardy.
Good morning. Thanks, David. So I'm just briefly going to discuss how borrowers might deal with lenders during this unprecedented time. I think David's already touched this vis-a-vis landlord and tenant relationships, but there certainly isn't here a one-size-fits-all approach. How a borrower approaches the current position should depend upon the nature of the asset, the type of tenants involved, and the terms of the borrower's existing funding arrangements. Generally, lenders are trying to work with landlord borrowers, but be aware that there is less appetite to work with borrowers in circumstances where facilities were in breach prior to this COVID-19 situation. I think the important thing here is that borrowers should speak to lenders, should demonstrate that they're trying to work with their lenders, that they're managing the situation and dealing with their tenants on a case-by-case basis. Lenders, in my experience so far, are very keen to see that borrowers are actively managing their properties and trying to maximise their income at this difficult time. When reviewing the position in respect of any non-paying tenant, consideration should be given to the matters that David has previously addressed. But it is important from a funding point of view to ensure that when you're having discussions with tenants, which might give rise to a need to vary or alter the terms of a lease, such discussions are had with tenants on a without prejudice, subject to lender consent basis, because most facilities will contain covenants requiring lenders to consent to variations to occupational leases. Before speaking to lenders, the borrower should ensure that it has reviewed its loan documentation, including the financial covenants contained in it, in order to understand what implications the relevant tenant requests and or demands in respect of rent payments will have on their facility. Although concerned to ensure covenant compliance generally, lenders certainly will expect capital and interest payments to be made where possible, and requests to lenders for concessions should, in my view, be commensurate with the position the borrower has been placed in by its tenants. I would advise landlords against taking the approach that some tenants have taken in simply demanding rent payment or interest payment or capital payment holidays as sort of an inappropriate, non-commensurate request may well provoke a more aggressive response from lenders. Depending on the circumstances, lenders may be willing to defer capital repayments or roll up interest, but they likely will expect to be paid the sums due to them under the relevant facility documents in due course. It's still relatively early days, and I'm aware of borrowers coming to temporary arrangements with their lenders involving capital repayment, deferrals, or interest roll-up. But as of yet, I've not seen a great deal in the way of formal documentation of such concessions, although I believe that will be coming in the future. When negotiating new facilities, if you're in a position to do that, you may wish to request inclusion of a corona clause in your new facility documentation. It's, as I say, it's early days, and we have not seen. I have not as yet seen a corona clause go into a facility agreement. My feeling, from my experience with dealing with lenders, is that such clauses will be heavily resisted. However, for example, a corona clause in a development facility that just builds in some additional time if sites are closed down might well be more palatable to a lender than a corona clause in an investment facility which seeks to turn off capital and interest payments or reduce capital and interest payments during any future government shutdown. But in brief, repeating what I said at the start, it's not a one-size-fits-all situation, and the individual circumstances of each facility and the nature of the property and the tenants really needs to be taken into account. And the important thing, I think, is to be having open dialogue with your lenders and looking to work with them. And that is about it from me. We've put our contact details up on the slide, so please feel free to contact either David or myself if you have any further questions or something we can help you with going forward. Thank you for your time.
Okay, thanks Chris. Thanks Dave. Hopefully everyone found that useful. Lots of practical advice and solutions there for landlords in working with both tenants and lenders as well. We are going to take questions now, so if you've not already asked a question and you would really like to, please do so, as I say, on the Q&A panel. We have had one question already, which is, are landlords/tenants documenting the payment holidays? If yes, how so? So Dave, I don't know if that's something that you might be able to answer.
Yes, certainly. Yes, we are finding that the landlords and tenants are documenting payment holidays. As I mentioned before, that we would view a side letter as probably an appropriate way of documenting an agreement of that nature. From both parties' perspective, a little bit of thought needs to be given as to what triggers what triggers the rent commencement, whether the rent is suspended or deferred, or rent-free or rent deferral. If it is a deferral, how that rent is then to be paid back going forward. But yes, it is definitely being documented. It's very easy, and I have seen landlords do this, and I completely understand why, to have an exchange of emails with a tenant whereby an arrangement of this is reached, but really care has to be taken. As I mentioned, you could inadvertently release a guarantor by agreeing to a variation to that lease, which could arguably be prejudicial to that guarantor by allowing that rent to roll up to a future event. So care does need to be taken, and a side letter is probably the most appropriate way of documenting an arrangement of that nature. It's probably too informal for a full variation of the lease.
Fantastic, thanks Dave. Hopefully that answered your question. Another one, I think probably for Dave, it's a bit of a longer one, this one. So have you advised any landlords requesting additional wording to the service charge clause within their precedent lease to give protection against breaching the clause in the event of services not being provided due to current and future pandemics? Whilst the current pandemic has granted property managers key worker status, it can't be guaranteed, and if and when another pandemic occurs.
Not as of yet, no. As I mentioned, the lease clauses around this are really lagging behind a little bit, in that obviously most people are turning their minds at present to the issue of rent and liquidity. But these are things that are going to have to be borne in mind going forward. As I mentioned, tenants are starting to think now about corona clauses, but that is a great point, in that a landlord has obligations in their lease to provide, for example, as you say, services, which they will be potentially unable to provide as a consequence of this. There would be a query as to, would the tenant really suffer any loss, given that the building isn't capable of occupation, and therefore the provision of services, they wouldn't be able to benefit from the provision of services during this period of time. But it would certainly be something that it would be sensible for a well-advised landlord to consider drafting around going forward. You do sometimes as well see an ability for landlords to, for various reasons, to withhold or temporarily halt the provision of services. So they might well be drafting that already picked it up in leases, but there's certainly it would definitely be something that would be sensible to give serious thought to. And as I say, leases will now evolve as a consequence of what is happening.
Thanks, Dave. We've had one more question. Has there been clarity on the definition on the moratorium on rent? I.e., does this capture service charge, insurance, and other sums over and above the principal rent due under a tenancy lease? Oh,
sorry, fellow.
You all right, Dave?
Yeah. I knew that was going to happen at some point.
Do you want me to repeat the question?
Yeah, no, it's okay. I got the question. Yes, I believe it does capture any sums reserved as rent. I don't think it means principal rent, so you couldn't say, you've not paid service charge, so we're forfeiting on that basis. I think it would be any sums which were reserved as rent and payable under the lease would be captured by the moratorium on forfeiture. The query, the point I raised in the slight question I have, is to whether a particularly cute landlord, for want of a better expression, could seek to draw money out of a rent deposit and then ask for that rent deposit to be topped up, and argue that is a breach of covenant rather than a non-payment of rent. That hasn't been explored. But to answer the question, yes, my view would be, and I think it is, any rent reserved under the lease, be it service charge, insurance, or other sums, you could not rely upon those not being paid to to utilise forfeiture. I think forfeiture, you'll be just currently sat on tenant insolvency or breach of covenant.
Thank you. So that's all the questions that we have had. So unless anyone has any more, we will leave it there for today. Thank you to our two speakers for their insights today, and thank you to all the participants for joining us. As we've said, please do feel free to get in touch with us with any further questions, or if you would like a conversation with any of the speakers on any of the topics raised today. As I say, we will be sharing the recording of this webinar with you, so please do feel free to pass that on to your colleagues and anyone else that you feel might benefit from the information we've covered today as well. So thank you very much. Please stay safe and take care, and we hope to see you all very soon.